Hello, my name is Yael Kidron. I'm the Director of Character Education at the Markkula Center for Applied Ethics here at Santa Clara University. And I'm really excited to talk today with Justin Driver, the author of The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for the American Mind. And I would like Justin can you please introduce yourself?
Yes, my name's Justin Driver. I am a law professor at the University of Chicago where I focus on constitutional law. I wrote the book in earnest in 4 years, but my interest in this issue dates back to my youth. I grew up in Washington, D.C., and I never attended my local schools, and starting in the 5th grade, I traveled very far from far southeast Washington to way upper northwest Washington to attend a school in a much wealthier, more sophisticated area of town. And during that long journey that had me on the bus to 2 different subways, I started thinking about what was I gaining as a result of this journey and what were my neighbors leaving behind. Brown versus Board of Education was 30 years ago when I was making this journey, but I was very aware that there were many schools in Washington, D.C. that were all black, and you could regard Brown versus Board of Education as nothing more than a rumor. And that struck me that sometimes there's a gap between law on the books and life on the streets. It's also true that I thought I was going to be a public school teacher when I graduated from college. And so I had a sense that students had constitutional rights, but it was only vague. And so one of the goals of the book is to try to write it in an accessible way so that non-lawyers can understand students' constitutional rights. There's a really important case called Barnett from the 1940s where the court says to disregard constitutional rights in the schoolhouse would be to teach youth to discount constitutional principles as mere platitudes and to risk strangling the free mind at its source, they say. And that's a very powerful message and one that retains vitality today.
I see the role of the Supreme Court is in influencing the system and the individual. So at the system level, we want to build a protective environment, an environment that cares about individual rights. At the individual level, we would like to build students' capacity to build the communication skills, the leadership, the civic engagement, both to protect themselves and to protect their friends or their society. So is there anything that you would like your readers to take away from those points?
It's a very interesting idea. I hadn't conceived of it in quite that way, but I think there's a lot to be said for that idea. And how I would think about it is that the schools are in many respects cultivating citizens, and in order to have the sort of engaged and interactive democratic society among adults, you have to begin that process when students are in school.
Let me read the first scenario. A student wears a t-shirt with a political statement to school. The teacher asks the students to wear the shirt inside out or to cover it. After the student refuses to do so, the school contacts the parents and assigns an out-of-school suspension.
So the foundational case in this area is one that we've spoken about called Tinker, and the rule that the court articulates is that if there's a reasonable forecast of a substantial disruption, then it's permissible to punish the student for the speech. And so in these sorts of cases, oftentimes the courts would look to whether the speech in question had created some sort of commotion and disturbance on the campus itself. So it partly would depend on the history of this particular political statement. But in my view, Tinker was a really important decision. It didn't go far enough in the sense that it can be understood as reading into the doctrine, what is sometimes referred to as a heckler's veto. And what that means is that if there are particularly sensitive listeners, then they can, by objecting vociferously, shut down otherwise legitimate speech. And so imagine, for example, with your scenario that you gave us, that the speech in question is a t-shirt that says "Make America Great Again," obviously a slogan that's associated with President Trump. In my view, the student should be able to wear that t-shirt, of course, even if students have objected to that and said, hey, you like Donald Trump and he's a racist or he's a xenophobe or something along those lines and I'm going to beat you up. Under current doctrine, it's possible that it would be permissible to suspend the student who refuses to take off that shirt, but that's not how the doctrine should work in my view. It seems to me that if students are threatening violence against someone for offering political speech that doesn't use sort of racial epithets or inflammatory language, then that speech should be protected, and that it's the students who are threatening violence that should be spoken to, and if discipline's to be meted out, it's that they should receive it.
Thank you. So the second scenario that we have here is a group of transgender students sends flyers to all students at school about pressuring the administration to allow students to use bathrooms based on their gender identity, not gender at birth. Mm-hmm. What should the school principal do?
I would encourage school administrators not to punish that sort of speech. It seems to me that this is plainly protected and the students are doing exactly what they should do, which is to say, petitioning their fellow students for a change in school policy. Assuming again that there's no sort of history of disturbance around these issues, that would be plainly protected under even the current doctrine. So the schools are often sites of intense controversies, and the Supreme Court of the United States did agree to hear a case involving transgender students and access to restrooms. It ultimately decided not to issue that decision because there was a change in the guidance from the transition from the Obama administration to the Trump administration. These are very important issues of the day, and it would be surprising, frankly, if the schools didn't have these sorts of debates that are happening in the larger society. After all, schools are very much found in the larger society, and so the same sorts of issues that divide American society broadly are often going to make their way into the schools as well.
Absolutely, and it's an opportunity to learn about civil discourse,
yes.
Right? How to talk about your opinions in a respectful and orderly manner.
Absolutely.
And finally, the scenario here is about an editor of a student-run school newspaper who wants to publish a story, but the story is about teachers' misconduct.
Mm-hmm. It's a very interesting case. The Supreme Court of the United States decided a case that's called Hazelwood versus Kuhlmeyer, which deals with the rights of student journalists. The actual facts there were that the student journalists wished to run two different articles that the principal objected to. The issues involved, the articles involved teen pregnancy and also divorce of students' parents. And so these issues made the principal uncomfortable, and he decided to pull the articles. In my view, that was deeply mistaken as a matter of policy. What could be more important for high school students to read about than the issue of teen pregnancy? Many of the students who were quoted talked about them not thinking they could not become pregnant on the first time that they had sexual intercourse, and these sorts of things that are very relevant to students. And in the 1980s, when this case happens, divorce is skyrocketing, and many students are wrestling with these issues and feel as though they are alone. So if I were the principal, would of course run these articles. Nevertheless, I think it was permissible for the principal not to publish these articles as a constitutional matter. I don't believe that he violated the Constitution by doing this. And how I would decide this if I were a judge, I would think about, there's a doctrine under the freedom of speech called the government speech doctrine, where the government, when it's speaking through one of its official organs, is allowed to say what it wishes to say. And so there are some problems that would arise from importing traditional First Amendment doctrine into the school newspaper, because under this particular factual scenario, the principal was in effect the editor-in-chief. He was responsible for reviewing the articles prior to publication, but under the First Amendment doctrine, people would regard that as prior restraint, where people are being prohibited from being able to speak. So I think that the solution, and if I were advising the students who wanted to run such an article, I would encourage them to do so through an underground newspaper, or even try to find a newspaper not associated with the school to cover this material. And that's actually what often ends up happening. And so if I were advising school administrators in their capacity, I would say to be very careful about pressing down and censoring articles, because often, even if you have that right under the First Amendment, it ends up blowing up in your face, in the sense that in the Hazelwood context, the school newspaper didn't run the articles, but the St. Louis newspaper ran the articles under a headline called "Too Hot for Hazelwood," and these articles end up getting actually more attention than they would have had they been limited to the school newspaper. So from a sort of strategic standpoint, I think it's probably unwise to censor articles in this way.
So from a strategic standpoint, you attract negative press. Mm-hmm. But from an educational standpoint, you also lose control, right? Mm-hmm. You lose the opportunity to provide guidance, to promote debate, and teach students maybe a different way of handling the controversy.
Mm-hmm. That's exactly right. In this particular case, Hazelwood versus Kuhlmeyer, the principal said that he objected to the articles dealing with teen pregnancy, because while the students were anonymized, he said that they offered enough sort of distinguishing characteristics that people would have been able to identify the individuals. And it seems to me that that would have been a perfect opportunity to work with the students in order to offer greater amounts of anonymity. And the same would be true in the divorce article, where a student was quoted as saying that my father plays cards with the guys and gets drunk with the guys and these sorts of things, and that's why my parents are divorced. But again, there you could have anonymized and just said a junior said this. And I think that if you are trying to give the students journalistic skills rather than simply sort of slamming the door on the article, the right thing to do in that case would be to call up the father and get his comment and ask for comment from the person who, and that's a much better way to go, and a much more educational way to go than simply trying to stamp out the speech itself.
So this is the book, The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for American Mind. And I would like to thank Justin Driver for being with me today. Thank you so much.
Oh, thank you. I really enjoyed it. Thanks for having me.
All right. Okay.